Good morning and welcome to the First District Court of Appeal. We have 3 cases on the docket today. We will take them in the order that they appear. After the second case, we will take a brief adjournment and invite the parties and counsel to join us in the rotunda for coffee. Following that break, we'll resume and hear the third case. With that, our first case on the docket today is Monroe doing business as McGee Tire Auto versus Jeff Parsons. Counsel, if you're ready, you may proceed.
Good morning, Your Honors, and may it please the Court. My name is Christopher J. Morrow, and I represent the defendant appellant, Monroe, Inc., in connection with this matter, and I'd like to reserve 2 minutes of my time for rebuttal.
So noted.
This case stems from the Florida Commission of Human Rights award of back pay damages to plaintiff appellee Jeffrey Parsons in a disability discrimination case. The commission awarded Mr. Parsons back pay in the amount of about $370,000, despite overwhelming record evidence that Mr. Parsons failed to mitigate his damages. The commission did so despite the fact that there can be no dispute that Mr. Parsons failed to engage in reasonably diligent efforts to obtain comparable employment, inexplicably declined 2 substantially equivalent offers of employment from other tire manufacturers in the area, and voluntarily resigned his employment from Monroe on June 19, 2019. The ALJ's findings on all of these points are legally and factually insufficient and require a reversal and a remand to the commission to send an appropriate amount of back pay damages, if any.
Under what standard do we review whether the employee exercised reasonable diligence and the lower tribunal's determination of that factor?
Yeah, so I acknowledge there's some conflict in our opening brief and our reply brief on that. The typical standard applied to review of damages awards is an abuse of discretion damages, an abuse of discretion standard of review. I do maintain, however, that there are some legal questions in this case that would be more appropriate for a de novo review, specifically what the legal effect of declining a substantially equivalent offer of employment is, what the legal effect of a non-compete agreement is on an award of back pay damages, and the legal effect of a plaintiff's resignation from their employer in terms of their entitlement to back pay going forward. But on the whole, I do acknowledge that it is an abuse of discretion standard in reviewing back pay.
Okay, with that in mind, and let's just take the opportunity that the employee would have to obtain substantially equivalent employment. Doesn't a covenant not to compete create a barrier? And if the employer hasn't relieved the employee of that obligation to comply with the restrictive covenant, doesn't that create a barrier to obtaining substantially equivalent employment?
It could, Your Honor. It could, but that's not what this non-compete does. And there's important factual context to bear in mind with respect to the non-compete. Mr. Parsons, by way of background, operated his own commercial tire shop in Pensacola for several years, and then in 2016 he sold that business to Monroe. And as part of the purchase agreement, Monroe became Parsons' employer, acquired the business, and had him sign a non-compete that's part of the purchase agreement, which states only that he was prohibited from operating, which is the exact word in the agreement, a commercial tire business.
And non-compete agreements are regulated under Chapter 542 of the Florida statutes, are they not?
They are.
And do you know what the damages are for violating a restrictive covenant under 542?
I don't off the top of my head, Your Honor.
Okay, so certainly if the employee is wrong about his interpretation of the agreement, there certainly is some damage that can be incurred, included attorney's fees and penalties, correct?
Sure, that is correct, Your Honor.
Right. So, so are you suggesting that if Mr. Parsons had gone to work for a competitor across the street and served as the manager of the location with no ownership and interest, that your client would not have sought to enforce that covenant not to compete?
That is not only what I'm saying, but that is in fact what happened. And the record is clear that not only did Monroe understand the non-compete to only restrict ownership interests, but Parsons did as well, and the record is replete with evidence of that. The first and most important piece of evidence on that point, and this is nowhere addressed in the ALJ's opinion, is that Parsons himself, at the hearing, was asked what he stood operating to mean in the non-compete agreement, and he admitted at the hearing that he understood the word operating to mean what it means, owning an agreement. And the factual context under which the non-compete arose is important here. Monroe was never concerned with Mr. Parsons becoming employed by another tire manufacturer. Remember, it just bought his business. It didn't want to have bought his business and have him open up another one next door and have to buy that one as well. So Monroe had no interest in restricting him from becoming employed with other tire manufacturers.
And taking all of the business and clients that Mr. Parsons knew, that would not have been at all a violation of the covenant not to compete?
That's not what the non-compete says.
All right, so are you suggesting that it was unreasonable for Mr. Parsons, at least as to the first two positions he was offered, to interpret that agreement to restrict him from that employment?
Yes, not only that it was unreasonable, but that's not what he understood the agreement to mean. And again, there's a crucial aspect of Parsons' testimony here that is very instructive on this point. It's excerpted in our brief at page 19. It's available at the record at page 451. And in that portion of the testimony, Parsons is asked, what did operating mean for purposes of this non-compete agreement? And he unambiguously states that it only restricted ownership interests.
But didn't he also unambiguously state that his understanding of the agreement was that he could not accept the two offers that were made? So, yes, he may have said, I understand this is what operating meant, but in the context of the actual offers that were made, he said, it was my understanding that these would violate the agreement.
There is conflicting testimony on that point, but his testimony on that, his testimony where he avers that he understood the non-compete to restrict employment as well as ownership is not supported by his behavior post-employment and not supported by the record. And it's important to note here what Parsons' only evidence of mitigation is in this case, and that is that in the months following his resignation from Monroe, he looked for Pensacola, Florida-based positions with 3 commercial tire companies, Goodyear, Bridgestone, and Hankook, all of whom participate in the commercial tire industry, and he was looking for jobs in those positions in the Pensacola, Florida area. So if Parsons truly believed that the non-compete restricted employment as well as ownership, why is his only evidence of mitigation aimed at doing just that?
Well, was it the trial court's role to resolve the conflicts in the evidence as to whether the agreement restricted Mr. Parsons from taking the first 2 jobs?
It is, Your Honor, but that does not mean that they're unimpeachable and they cannot be reversed for clear error. And that's what I think that this case is. And the evidence for that is that not only this isn't a situation where the ALJ weighed the evidence on both sides and came to the conclusion that Parsons' credibility outweighed that of Monroe's witnesses. This is a situation where the most crucial evidence in support of our failure to mitigate is nowhere in the award at all. And the portions of Parsons' testimony where he clearly states that he understands what the meaning of the non-compete is nowhere in the ALJ's testimony. The fact that he was looking for jobs, his first step in mitigation was looking for jobs that under his flawed reading of the non-compete would have violated it, is nowhere considered in the opinion. And again, Your Honor had asked previously about whether Monroe would have enforced this non-compete against him had he actually accepted those offers. Again, he did end up filing the non-compete. In 2021, he ended up accepting a position with GCR, one of the employers that ended up offering him employment in the months following his resignation. That employment is well within the geographic scope of the non-compete, and Monroe never once sought to enforce that non-compete against him.
Wasn't it in Monroe's interest not to seek to enforce that non-compete in light of the mitigation?
I don't think so, Your Honor. No. And if one was to consider Monroe's financial interests, again, if he had become employed, or if it had taken the position that the non-compete barred him from becoming employed, it would have possibly been on the hook for paying him a substantially higher sum of damages.
Okay, so let's move on to the voluntary resignation.
Sure.
And your argument there. So you don't contest the commission's finding that there was an age discrimination. There was age discrimination here, and at least as to March of 2018, Parsons was constructively discharged at that point, correct?
I do contest that he does not claim that he was constructively discharged.
Okay, so there was no constructive discharge at all?
No. So, and the The crucial document on this point is his settlement at the Workers' Compensation Board. And in that document, he says that this settlement terminates his employment with Monroe and he agrees not to return to work with Monroe. Now, I understand that the ALJ, for purposes of setting back pay, had used his last day of work, not the date of resignation for submitting back pay. But at the time that he settled his case with the Workers' Compensation Board, that was his formal date of resignation. And that was a voluntary, knowing resignation that was made while he was represented by counsel. And in Parsons' opposition brief, the only argument that he makes in response is that he was forced to accept the workers' compensation settlement. But that is not what happened. That's belied by the record. Mr. Parsons, the document is clear that he made an informed, knowing, and voluntary decision to execute that document while represented by counsel. So he can't claim ignorance of it after the fact.
Yeah, so is it your position that when an employee agrees not to seek reinstatement and voluntarily resigns their position, as a matter of law, they cannot seek back pay?
Yeah, my position, Your Honor, is that back pay as a remedy, in order to be available, the employer either has to be terminated or, if they resign, allege that they have been constructively discharged. Here, Parsons resigned by virtue of the workers' compensation settlement, and he has not alleged that he has been constructively discharged. Therefore, the back pay award in any amount is improper.
So that would include the period of time between his last day at work and the time of signing the agreement? I mean, because the order, of course, brings back pay all the way up to the present.
Correct, yes. So for the period of time that starts from his last day of work and ends with the workers' compensation settlement, he's already received payment in form of the workers' compensation settlement. The effect of the back pay award and the effect of his resignation is that from the date of resignation, he is unavailable to receive back pay because he has resigned and he has not alleged that he has been constructively discharged. And even if the court were to assume even if the court were to take the position that that was not correct, we maintain that at most, any back pay award should be limited to 6 months, because 6 months after his resignation was the date that he received 2 substantially equivalent offers of employment from GCR and Monroe and turned them down. And again, it's important to, one of the most crucial aspects in trying to discern what the party's understanding of the contract was is first what the contract says. It says operating. Operating is not employing. An employee who is in a sales management position does not operate the business. And again, the factual context in which the non-compete arose is very important here. Monroe was trying to prevent him from starting another commercial tire business after it already bought his assets. That is the only thing that it was concerned about, and that is borne out by the party's behavior after he resigned. It did not seek to force the non-compete against him, even though under his reasoning he ended up violating it. And I now see that I'm into my rebuttal time. If Your Honors have any further questions, but I will rest for rebuttal. Thanks.
Thank you, counsel.
Morning to the panel. May it please the court, my name is Ryan Barnett. I'm here on behalf of Mr. Parsons. I'd like to address a few of the issues in turn. With regard to the standard of review, as we argued in our brief, we do submit, and I believe it's been conceded that this is an abuse of discretion case under the 11th Circuit authority, the Miller decision. Back pay is governed by abuse of discretion. In terms of how the court looks at that question, most of the law flowing from this comes out of the Title VII statute and its binding authority following that. Particularly, I think the Nord case, which we cited in our brief, is helpful. Ultimately, what is left for the court in determining this question of reasonableness is really has to do with common sense, as we argued in our brief. That the court is urged to look at particularly the non-compete in the situation. None of the authority that's been cited really deals with a non-compete situation. And in this case, as the Nord decision points out, the burden was on the appellant at the trial court level to show that there had been inadequate efforts to mitigate damages.
So let's assume that the lower tribunal had looked at the evidence and said, well, you know, as to those two offers, we agree that the non-compete agreement restricted the employee from accepting that employment, but we still find that the efforts were inadequate to, you know, reasonably seek to mitigate damages. Would you concede that there would be no abuse of discretion there?
I would.
Okay.
I think that ultimately that would have been a question of fact. That's what trials are for. The trial court's job is to sort through the facts, make those determinations. And as we've pointed out time and again, appellants have come to this court arguing that competent substantial evidence questions are really de novo, or that abuse of discretion are really de novo. And I understand, you know, they're doing what they need to do, but in essence, they're asking for a retrial. They're asking this court to retry this case, and I think that, again, is not the role of the appellate body. The appellate body is to look for legal errors, and I would submit that there are none here.
So was the lower tribunal's determination that operating would include, you know, managing or working in another business, is that unreasonable as a matter of law, or was
No.
there any legal error in that determination?
I see no legal error there, nor do I see any you know, case law that was cited by the appellant on that question. And I think, in particular, one thing that's interesting, if you look at the testimony of the general counsel at the second damages hearing, she acknowledged at that point, and this is important because Mr. Parsons did ultimately take a position in Montgomery, Alabama, but partly it was based on the general counsel being asked at the hearing, is this going to violate the non-compete? And she said no, and that's part of the reason that we asked her that. But one of the other things we talked about, and it was made very clear, is that her definition of operating is not supported by the English language. Nowhere in a dictionary or anywhere that the definitions flow from, case law, statute, otherwise, does the term operating mean ownership. They are two separate words. And in Florida, ambiguities are construed against the drafter. As the ALJ pointed out, the employer was free to phrase that document however they wish. But by defining it as operating, which is what Mr. Parsons would do as somebody with multi-decades of experience in running tire shops and managing them, that we would submit respectfully would clearly be operating, and it would have been in violation.
Sure.
So, if I'm reading the record correctly, it said that McGriff Tire offered your client a job as an outside sales rep. So if your concern is that he is managing another entity that might compete with them, how would that fall under management?
I think operating broadly does not necessarily mean managing. Again, operating can be.
How is an outside sales representative an operator?
Well, again, if there is ambiguity, it's on the appellant, I would respectfully submit. Mr. Parsons' interpretation of that language was such that it would violate his non-compete. And if the appellant had clearly defined that term and had you know, made it more broad or narrow or whatever the case may be, I think it would be a different situation. But that language, the clarity of that language is on the employer. They are the ones that draft these documents. They slide them in front of employees, and you sign or you don't. If they want it to say something clear, then it's on the appellant, would be our position.
So, I mean, I'm asking you, do you find that it's reasonable to conclude that one could read a document saying that you can't operate something and you get an offer as an outside sales representative, that it would violate it?
That ultimately, I think, is the question for the ALJ, and the ALJ determined that I think is the issue here. And in terms of abuse of discretion, I would submit that the ALJ's reading did not reach that high threshold.
So let's turn to the voluntary resignation. So the employee entered into the workers' compensation settlement, right? And let's first take the period from March 18 until the time of the settlement. Was Mr. Parsons compensated through the workers' comp settlement for back pay?
As I recall, he did receive some back pay benefits, which I believe the ALJ, as I recall, factored into. There was an offset essentially in his award.
A complete offset for that period?
As I recall,
All right,
Judge. My recollection is that there was an offset for that. I believe in the proposed order that we submitted, that was something we also conceded, that there was an offset granted dollar for dollar for whatever he received for the workers' compensation benefits.
So then, as to the back pay awarded from the time of the workers' compensation settlement going forward, when the employee voluntarily resigned and agreed not to seek reinstatement, what legal effect did that have, and are you aware of any case, any decision where an employee has voluntarily resigned their position, agreed not to seek reinstatement, and then was found entitled to receive back pay?
I'm not aware of a decision that addresses that question, and I don't believe any of the briefs really cite any authority that's helpful on that. What I would suggest is, again, and we pointed to this, I respectfully argue it's form over substance. His employment had been ended at that point, and it's to me, a curious argument to say that although he had been discriminated against, his employment had ended. Later on, he signs a workers' compensation settlement package, which if you look at the documents carefully, anything that purports to suggest that he's waiving any claims have been lined out, they've been changed. I believe that the appellant is arguing for a broad expansion of what that means in terms of common sense. If your employment has been ended, and then you sign a workers' compensation settlement, and as part of that, you resign your employment, which you've already lost, I think that it would be, to me, it does not make sense to say that should bar his ability to recover.
But voluntary resignation has a specific meaning under Title VII, all the anti-discrimination statutes, does it not?
It does, but in this case, recall again that the Workers' Compensation Act is very, very narrow in its jurisdiction and what it covers. This settlement was executed as part of a workers' compensation settlement. It was not executed as part of a general release for a discrimination case or some other action. It was very, very narrowly tailored really to the workers' compensation case. So I would just urge that you have to look at the context of how that agreement came into place.
I agree that, it may not be a general release, but that says that, anything that happened before may actually still be subject to suit, and that, this doesn't waive that. But really here the question is whether there was a termination of the relationship between your client and the employer such that they could not seek back pay after it. So it's really not a question of whether any claims were released that existed during the employment relationship. It's whether he's entitled to something that happened after. Am I missing something?
I think, for instance, if you look at the one case that was cited by the appellant dealt with a situation where an employee had taken another job and then resigned that position. And to me, that the reasoning in that case certainly comports with my understanding of the state of the law. But I think in this case where he had not taken other employment, he was bound by the non-compete, and he resigned or voluntarily resigned as a pro forma part of what is really a workers' compensation settlement in the very, very narrow context of what those courts have jurisdiction over. I respectfully submit there's no authority, there's no binding legal authority that says that bars him from recovery under either Title VII or the Florida Civil Rights Act. So I think that would just be a broad expansion that's not supported by the current state of the law. And again, in terms of abuse of discretion, it'd be one thing if there was a case directly on this that says that the ALJ erred, but there's not. And so I would urge that this would be a broad expansion in terms of what the appellant's asking you to do here. I'm happy to answer any other questions. All right, I'll yield my time.
Thank you, counsel.
Thank you, Your Honors. So I want to continue the discussion on the back pay question. My friend on the other side has stated that there's no discussion in the briefs about whether back pay is proper when a plaintiff resigns their employment voluntarily. That's not true. And the most fulsome discussion of this is at our reply brief on pages 16 and 17. And the case chiefly on point is Pace v. Alpha Mutual Insurance Company. And that case is from a district court in Alabama, I believe, from the 11th Circuit, that specifically says in order to assert a claim from back pay where an employee has resigned, The employee must allege that they have been constructively discharged. And that might sound like a bit of a harsh remedy for plaintiffs, but it's important to remember here that under the anti-discrimination laws, back pay is not the only available remedy. It was the only remedy awarded here, but a plaintiff in this situation where they resign and are ineligible for back pay can also seek punitives, can also seek emotional distress damages and attorney's fees. So while Parsons' argument that it might seem unfair or illogical to have back pay be totally unavailable in this situation, that is the clear command of Title VII and the anti-discrimination statutes, not only in Florida and in the 11th Circuit, but across the country. Where an employee resigns, constructive discharge is the claim that entitles that employee to back pay. And without a constructive discharge claim, any back pay award is improper. I want to also briefly touch on the fact that plaintiff my friend on the other side, both in their brief and in this argument, has stated that, has emphasized that this is the appellant's burden to show that a plaintiff has not mitigated their damages. That's true. I don't contest that it is our burden. But it's important to remember that meeting that burden rests entirely on what the plaintiff does. And when the plaintiff, as the plaintiff did in this case, does next to nothing, he can't argue that we haven't met our burden because there's no evidence that he failed to mitigate. There is only one piece of evidence in this record that Mr. Parsons made any attempt to mitigate his damages, and that's that he just searched online without submitting any resumes or applications to find a comparable position. That does not meet the threshold for mitigating damages under Title VII or the state analogs. With no further questions, I yield the rest of my time. Thank you, Your Honors.
Thank you, counsel. Thank you both. We'll give counsel a moment to reconstitute for the second case.